We're going to go ahead and get started with the panel. First, I'll just introduce myself. My name is Lawrence Hinkle. I'm an attorney at Dreyer, Stein, Kahn, Brown, Woods, George, practicing in entertainment litigation in all areas, music, film, TV, etc. I'm also the chair of the litigation division of this forum, and I'm delighted to be the moderator of this panel, which includes some of the finest entertainment litigators that is known in this world.
At least in this hotel.
And in this room.
At this table. On this table.
On this table.
And we're going to be talking about some of the hot legal issues that are prevalent in the entertainment litigation area today. I'll start off with introductions. We'll go through some of those topics, and then we'll try to leave some time at the end to have some questions from the audience. First, let me start with Marty Singer, who's to my left. Marty is a founding member of the law firm of Laveley & Singer Professional Corporation, which was formed in 1980. He specializes in entertainment and business litigation and has been involved in litigating all areas of business, commercial, intellectual property, defamation, accounting, and entertainment-related matters. He has tried over 100 arbitrations and jury trials and has represented some of the most famous actors, recording artists, writers, producers, and directors, including, for example, Arnold Schwarzenegger, Bruce Willis, Demi Moore, Halle Berry, Sylvester Stallone, Halle Berry, Eddie Murphy, Nicolas Cage, Harrison Ford, Celine Dion, Jim Carrey, Stevie Wonder, Whitney Houston, and Kelsey Grammer. In 2005, 2006, and 2007, Marty was selected as one of the top 100 attorneys in California by the Los Angeles and San Francisco Daily Journals, and was also named as one of the 500 leading lawyers in the United States by Law Dragon magazine. Marty Singer. Next, to Marty's left, we have Patty Glazer. Patty serves as head of litigation department of Glazer, Warren, Fink, Jacobson, Shapiro, LLP. She is a business trial lawyer and provides general legal advice to publicly and privately held companies in all areas of real estate, contracts, antitrust, entertainment, banking, and securities. She has handled numerous significant cases, including, for example, she was lead counsel in the MGM Grant Hotel retroactive insurance litigation, which settled for approximately $76 million. She served as lead trial counsel in the case against Kim Basinger, in which the jury rendered a multi-million-dollar reward. She was lead counsel in a case against Lucasfilm, where a jury awarded several $1 million, lead counsel in a case defending the Walt Disney Company and obtained a defense verdict. She was lead counsel defending public companies and their officers and directors in shareholder class actions, derivative lawsuits, and government proceedings, including SEC investigations and enforcement matters. Patty Glazer. Next, we have Larry Stein. And Larry Stein heads Dreyer, Stein, Kahn, Brown, Woods, George's entertainment and media department. His clientele includes writers, producers, directors, actors, musicians, entertainment guilds, talent agencies, personal and business managers, and independent production companies. Larry has been named Entertainment Lawyer of the Year by the Beverly Hills and Century City Bar Associations. He was profiled in the California Lawyer magazine as one of the top 5 A-list entertainment lawyers changing Hollywood. He was listed in Entertainment Weekly's 101 Most Powerful People in Entertainment, listed in the Best Lawyers in America and the Daily Journal's 100 Most Influential Lawyers in California. He is among the Law Dragon 500 leading lawyers in America and was ranked as a star performer last year and this year in the publication Chambers USA, America's leading business lawyers. And in his spare time, he is an adjunct professor teaching entertainment law at USC and the Stanford Law Schools. And finally, but not least, Robert Schwartz. Robert Schwartz is a partner at O'Melveny & Myers at the Century City office here in the LA area, and is a member of the firm's business trial and litigation practice. During his 24 years at that firm, his business litigation practice has involved significant matters, including, for example, the MGM versus Grokster copyright infringement suit. His clients have included, for example, Warner Brothers, Time Warner Entertainment, MGM, New Line Cinema, Sony Pictures, and the Walt Disney Company. He is named in the Best Lawyers in America and Chambers Guides to Leading Attorneys, as well as the Southern California Super Lawyers and Log Tracking Guides. That is your panel. Let's start off by talking about the copyright infringement area. But let's start off with Bobby.
Okay, great.
Now, Bobby, you were lead counsel in the MGM Grokster copyright infringement case I mentioned. What are the ground rules that the Supreme Court set in Grokster? And in the wake of that decision, where have the lower courts been drawing the line in terms of liability for copyright infringement?
Thank you very much. First of all, thanks everyone for coming out on an early on a Saturday morning. Rolling out of bed to get here at this time may not be the most fun thing you've done, but let me start talking about the Grokster case and then its after effects by first saying I was not the sole lead lawyer in that case. There were a very large number of terrific lawyers around the country that I worked with on that case. My role was to stand astride two different business philosophies that were very important in the case. I represented the Time Warner Entertainment and content companies in that case, HBO, Warner Brothers, New Line, Turner, et cetera. And the case was filed in late 2001, and I was brought in, actually I think David Kendall at Williams & Connolly originally filed the lawsuit. I was brought in immediately for the content, including the record side, because at that time, Time Warner was heavily involved in a merger with AOL, less important to the company's business today, but they were concerned that the plaintiffs in the case not take positions that would undermine AOL's ability to operate as a business where people were posting content on the internet. So I was kind of the referee amongst a very large group of talented lawyers, and I don't want to diminish or take away from any of them the contributions everybody made in the outcome of that case. Anyway, the basic holding in the case, June 2005, was, I'll just read a little thing if I can. One who distributes a device with the object of promoting its use to infringe copyright, as shown by clear expression or other affirmative steps taken to foster infringement, is liable for the resulting acts of infringement by third parties. That was the 9-0 decision written by Justice Souter, and it was an attempt to balance the interests of technology and the interests of content creators that were seemingly at odds between the Sony case that was a pro-technology case and the Napster case, which was a pro-copyright owner case. So Justice Souter wrote, "We're mindful of the need to keep from trenching on regular commerce or discouraging the development of technologies with lawful or unlawful potential." And what the court did was adopt a new rule of copyright infringement, secondary liability, called active inducement. And as the court noted, it was based on purposeful, culpable expression and conduct that would do nothing to compromise legitimate commerce or discourage innovation having a lawful purpose. And since then, a number of courts have had to grapple with what that means, whether copyright infringement in a secondary sense is now an intentional tort or not. But I thought it would be helpful very quickly to just go back a little bit into the history of the case to explain how the Supreme Court ended up where it did. As I said, the case was filed in late 2001 after the Napster outcome. There emerged, when Napster was shut down by Judge Patel, a new service called Kazaa and a related service, Streamcast and Morpheus. They all operated a peer-to-peer network, and the technology was different than the Napster technology in that the files were neither the search list of available files was maintained on the defendant's websites, nor the files themselves. They said they had no liability because all they did was make available for download a piece of software that would enable the user to join into a network that was entirely self-creating and self-sustaining, a perpetual motion machine. And since they didn't do anything beyond that, they shouldn't have liability. And so Judge Wilson at the first status conference said, is this Napster or is this Sony? Is this a software case or is this an infringement case where a party is really getting involved? And the defendants felt they'd really outsmarted the law. We struggled with that and lost in front of Judge Wilson, granted summary judgment for the defendants, finding that all they did was distribute software. They had no control over downloaders at the time they downloaded. They had no knowledge of it. And putting aside whether that was factually accurate, it was a compelling rationale for the outcome. when we were in front of the Ninth Circuit, my view was we had failed to articulate a viable legal theory that would impose liability on what I would call the bad guys without sweeping in Xerox and Apple and legitimate technology innovators. The problem with these defendants is their view was they wanted to offer and supplant the demand for Napster when it was shut down. They invited people to come in, use the service. When the lights went out on Napster, where did you go? You came to us. And so my feeling was we needed to come up with a rule of law and a principle behind it that would enable the courts to differentiate between those two. After all, my role was to protect AOL as we went after this form of infringement. And when we were in the Ninth Circuit, I still felt we didn't have the right legal theory behind it, and I said we should go back to first principles, at least to the Sony case, and recognize that when Sony adopted the staple article of commerce doctrine from patent law into copyright infringement, it was pulling it straight out of the patent statute, section 271C. And I looked at it, and it's right there in a footnote in Sony. There's a section right above it, 271B, called active inducement of patent infringement. And it talks about what that is, and it's kind of intuitive, I'm sure, in terms of active inducement. It's a common law principle. But the interesting thing about that is, as a matter of patent law, if you engage in active inducement, even if your product is capable of non-infringing use, if it's a staple article of commerce, but you intend people to use it to infringe, you have liability. So my view was this totally took Sony out of the case, and the question as to whether this software could be used for non-infringing uses, which clearly it could, was something we'd no longer need to overcome. Didn't find enough fans at the Ninth Circuit stage, but when we lost there and we were really desperate after the Supreme Court granted cert, we made this a module, a small module of our opening brief, and the respondents didn't really address it very effectively. We said a little bit more about it in our reply, and when we came to oral argument, it was all the court was really interested in. And then obviously, as we were reading the decision, 9-0, it was clearly something that had grabbed their attention. So since then, Judge Wilson has granted the plaintiff's motion for summary judgment and imposed liability. So what's happened after that? As Patty's going to get into in the next topic, there have been lots of lawsuits against direct infringers for making content available on the Internet. That's a different kettle of fish that we'll talk about later.
But Bobby,
sorry.
Answer this question. Clearly in the Napster case, which is 2000, obviously before Grokster. Napster, the dicta in that case says the Napster users who upload file names to the search index for others to copy violate plaintiff's distribution rights. That's a Ninth Circuit case. There is no Ninth Circuit case subsequent to that, touching on how Grokster impacts Napster. How does it impact it as a practical matter, if at all?
How does Grokster impact Napster
Yes.
with respect to that issue?
Yes.
I don't think it does, because I think, and there have been some cases that I know that I think you have.
There's some district court cases
right.
that touch on this, but there's no Ninth Circuit case.
As to whether the mere offering to upload,
It's not just offering to upload. It is actually, why else do you have something on a file sharing
network
if it's not for somebody to use it?
Well, I guess I'd make 2 points. First, the defendants in the Grokster case essentially conceded that the individual users were engaging in copyright infringement when they have made these files available. So Grokster never gives us any guidance on that because the defendants gave the issue up. The other thing is, though, there may be a technology difference between some of these applications. In the Grokster software, the file, it stores by default all of your content. In other words, let's say you have a computer and you've got lots of songs on it. When you download and install Grokster, it does lots of things you may not know about, or it did. It pulls all of your content into a Grokster shared folder to make it available to other users, whether you know that or not. And so at that point, even if you had thought you had like this kind of safe content where you ripped your own CDs, you had no intention of sharing, by default, you're now making this content available for sharing. And so you may stumble into liability if courts do articulate, as one court kind of has, that merely putting it on your folder and making it available means you're engaging in infringement of the distribution right. So I mean, as an aside, I think one aspect of Grokster is there was a lot of malware in it that people really didn't know about that they were using to monetize the site or their software. And that's one instance of it where people, I think, got exposed to liability. But let me not get too far ahead of that, because I want Patty to be able to talk about those cases in more depth. I want to focus on the secondary liability lawsuits that came after that, not necessarily by the industry, although there were a few, and I don't want to take up too much time here, because we do have a lot of topics to cover, but let me just cover a few of them. There's this magazine called Perfect 10, and it has...
I know it.
And
Larry Post. I don't know.
do they have parties like, pajama parties? Never mind. That's the defamation, privacy clip down the hall. And they have sued everybody that has in any way come in contact with their images that have been uploaded on the internet. And one such entity is Google. The image search on Google is a very powerful tool, and so is the one on Amazon. And Perfect 10, among the many people it sued, including Visa and others, sued them saying, look, you're allowing people to do Google searches, image searches for Perfect 10 images, and you return to the user's thumbnails, which are thumbnails of our copyrighted content. You are liable for contributory or vicarious copyright infringement. And the district court, Judge Matz here in the Central District, actually enjoined Google and Perfect 10 on the basis of finding that they could have done a better job of monitoring their site, and just to capsulize his holding, he decided to enjoin them. They took that up to the Ninth Circuit, and Judge Ikuda, who is not a copyright expert, her background is land use and environmental law, reversed the injunction without directly really getting to the key of it. She said that, but she announced some rules that I think are a little problematic for the content industry or others. One is, she said, Grokster imposes liability if the defendant takes steps that are substantially certain to result in direct infringement. Wow, that is an extremely broad articulation of Grokster. I mean, remember, Grokster was supposed to be active inducement as opposed to passive inducement. You have to do something. You advertise the infringing aspects of it. You market it. You tell people things about it. You give them customer service that says, hey, the really good stuff you want to download is over here. Just taking steps that are substantially certain, maybe that's pushing it a little too far. But in any event, she remanded for a couple of reasons. One, didn't think the DMCA analysis was complete. So the case went back and left a lot of questions unanswered. And just, again, keeping it at the survey level of this, there's a guy named Bob Turer, who's a news footage gatherer and librarian, sued YouTube because some of his footage, I think including the famous Reginald Denny video, was being posted on YouTube, and he claimed copyright in it, and so he sued them for secondary infringement. Judge Cooper, also sitting here in the Central District last year, declined both sides' cross motions for summary judgment, and the important one was her denial of the plaintiff's motion against Turer, and what he said is that basically because there was insufficient evidence, she wasn't going to grant the plaintiff's motion, she wasn't going to grant the defendant's motion because, frankly, as much as I respect her, she doesn't like to grant summary judgment motions if she can avoid them. And then eventually Turer walked away from the suit. So we really don't have an articulation post-Grokster, even though she analyzed the case, as to what the standards would be. Then Harvey Geller, very knowledgeable businessman in the record industry, head of litigation for Universal Music Group, has filed a series of lawsuits against MySpace, Crackle, and one other service, claiming that these social networking sites that allow people to post videos and music, including Universal Music Group compositions, violate the Grokster rule. The problem there is the cases never went beyond discovery. They were settled. The mother of all cases is, of course, still pending. It's the Viacom content company's case against YouTube and Google. That case probably will not be tried till next year, or motion practice really until next year. The only case that's really gotten far enough to a decision is it's another porn-related case called IO Group v. VO Networks. And in August of this year, Judge Lloyd, sitting in the Northern District of California, granted the defendant's motion and said that what the defendants had done wasn't sufficient to create liability under Grokster, even though this is a user-generated site, and they even had some supervision over the website. But the important aspect of it is that he decided that the DMCA safe harbor provisions under Section 512 would protect someone against liability for active inducement liability. And in that case, the standards were met. Whether they are in the mother of all cases is yet to be decided. But if that case is applied in the in the Viacom case, it will resolve a lot of the issues, because Viacom has asserted that the DMCA does not protect someone against active inducement. It's an intentional act, and that was nothing Congress ever intended to shield. And yet now we have a district court judge in the Northern District of California saying, no, even under Grokster, there is protection under the DMCA. So anyway, I apologize for speaking quickly, but I don't want to take up too much time, so that's what I wanted to tell you.
I know Patty's going to go through some case law too, and I don't know how sophisticated the audience is in terms of the cases, and maybe they want to hear it, but I think it'd be interesting for us to give them a more generalized approach to the thing, because you're doing it on a microcosm. I think on a macrocosm, what does this mean for the industry? How are these cases going to impact the film industry, the music industry? We used to have windows where we would distribute film one way, first in the theaters, and then we'd go to foreign, and then we go to pay TV, and then we go to cable, and then we go to free TV, etc. In music, we know how they used to produce and distribute music content now. In publishing, the same thing. These cases are going to have an enormous impact on the way in which the industry functions, and I just wonder whether any of the panelists
I could give you a quick thing on that. I think that cutting through all of it, the fact is what these cases illustrate is that no matter how good your lawyers are, the internet is more powerful than you, and than you are, or your lawyers are. And so what the industry is doing is looking towards moving business models to eliminate the windows to the extent they can do so without irritating the National Organization of Theater Owners, and provide day-and-date release of content in multiple formats, tiering the pricing so that they can recapture some of what they're losing. And even now, there's a lot of talk in the industry that Blu-ray is dead or will be dead in 3 years, that everyone's going to get high-def content through their cable system or through their satellite system or through their phone system. No one is going to be buying physical goods. And so the video window is going to potentially wither. Now, people have been saying that for years. The problem is, at the same time that's happening, the studios are investing through joint ventures hundreds of millions of dollars in digital cinema display technology in theaters, not for the home use, but for theater use. And obviously that would be rendered valueless if you could sit at home and pay $50 to see the Indy 5 or...
I don't agree with that. I actually think that people, I don't disagree with your legal conclusions at all. But I think people want to go to theaters. I think that somebody has figured it out, that they enjoy that social experience. And I don't think that goes away by putting something on a little screen that you have to sit there and hurt your eyes looking at, or a big screen. I think ultimately people like the social experience. I don't think theater...
I actually agree with you, and this is rare. But I do agree with Patty. I think there is a different experience when you go to it. And I think what the industry has done, unfortunately, is focus all of its attention. I think the RIAA was the biggest example of it, in trying to prohibit something that you can't prohibit. It's like prohibition. You say the internet is bigger than you are. I say people want content. They want it now. They want it when they want it and how they want it. I think what the industry has to do is refocus its energy on the different ways of delivering that content rather than trying to prevent people from getting the content. And if they change their focus, and I think there is a place for the theater experience. I think there's nothing like going to a large theater with other people and having the special effect. And they can do things at a theater you're not going to be able to do in your house. You know, if you're watching an earthquake, they can shake you up in a theater. You know, I mean, they can do lots of different things that make it appealing. They can show you stuff that you can't get on the home experience. They can feed you. They can give you wine and other things to make it more appealing to go to a theater. The same thing is true in music. I think there will always be live venues. I don't think just because you download that's going to eliminate live venues. So I think the industry has to change with technology instead of fighting technology, and that's what I find so offensive about a lot of these cases. I think they're picking at a little teeny problem.
Let's just touch on something that Bobby mentioned earlier, and that is that relates to music media files. And this is something that I think would impact all of us on a daily basis as individuals as opposed to just companies. But Patty, can you talk about this? Does an internet user commit copyright infringement by storing a music media file on his or her computer in a location that simply makes it available for others to copy, even if there's no evidence that anyone has actually downloaded that music file?
The cases all have evidence that somebody had them in a file sharing place for a reason. They were file sharing. But having said that, there are 2 circuit court cases that support, but they're not directly on point, this notion of making available is good enough. There are 3 district court cases in the United States, just 3, on point that say making available is sufficient. And there are 2 district court cases on point saying making available is not sufficient. I suggest to you that there is no other reason in the world you would have this on a file sharing platform other than to share. And to actually prove that somebody is file sharing is impossible. And let me just give you a little bit of background. It started with the record companies, but it's not just record companies. There are a couple of motion picture companies that have filed these lawsuits as well. And initially it was these peer-to-peer sharing web services that Bobby is talking about. But it's gotten to the point now they're looking at individuals, and there are these fines, and if you do it 5 times, it's 5 times whatever the penalty is under the statute, which is not inexpensive. And I think it's an appropriate thing for record companies and motion picture companies to do is to go after these people who are downloading them onto file sharing platforms solely for the purpose of letting their friends and others use them free. So let me go forward. What happens is that the record companies have done this more than the motion picture companies. They hire investigators who scour the internet for IP addresses whose hard drives possess these copyrighted materials in a shared file folder. The investigators then take a snapshot of the hard drive containing the copyrighted material, of course. And then the record industry finds out the person's identity via subpoena on the internet service provider's records. And then the record company or the studio is then able to allege that on a particular day, at a particular time, the person's IP address, believe it or not, I mean these are amazing to me, had copyrighted protected materials stored on the hard drive in a file sharing folder. Section 106.3 of the Copyright Act provides that the owner of a copyright has the exclusive right, quote, to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership or by rental, lease, or lending. And because the record company can only take a snapshot, or a motion picture company, of an individual's hard drive at a given moment in time, the record companies are asking courts to adopt the position that possession of copyrighted works in a shared file on your hard drive is actionable. I think, Patty Glaser thinks, nobody may agree, but I think it's perfectly logical and appropriate. Now,
I don't agree.
I know. The pro cases, there are 2 circuit court cases that move in the direction of making available is sufficient.
Bobby doesn't agree either.
You guys are communists.
To balance it out, I agree with Pat, even though I disagree with her.
You represent talent, of course.
Yeah, but talent,
It depends.
But talent wants to get paid compensation.
Absolutely.
And this is part of the problem, is by engaging in this conduct, that's where people are not getting paid. They're not getting paid their residuals, and substantial income is being lost, specifically in the record industry and the music business.
But that's because they've established a certain method of paying artists and doing it. There's a lot of different ways of compensating. All you have to do is find new business mediums for compensating people.
Now when people take things and download it and give it to their friends. There's no way to
If you,
compensate them.
listen, when
But anyway,
iTunes,
I don't want to get into this debate. Patty, go ahead. Finish.
but that's what we're supposed to be doing. We're supposed to be getting into this
Talking
debate.
about new developments, Larry.
That's right.
What I want to do is,
You're both right. You're supposed to talk about it and debate about
Let's
it.
give Patty the
all
floor.
I want to do is just give you the sites so you can take a look at the cases yourself, and then we can have this arm wrestling. There are the two circuit cases, which are not directly on point, but certainly lead you in this direction. It's Hodling versus Church of Jesus Christ of the Latter-day Saints.
I told you.
That's a Fourth Circuit case, so take that for what it's worth. It's 118 F. 3rd 199, 1997 Fourth Circuit case. The case that we mentioned earlier, A&M Records versus Napster, is a Ninth Circuit case, but it's 2000. It's before Grokster. But it also supports the notion, because the dicta, it's not a holding, the dicta there says, quote, Napster users who upload file names to the search index for others to copy violate plaintiff's distribution rights. That A&M Records case is 239 F. 3rd 1004. Then you have three district court cases that say making available is absolutely sufficient. The most recent of which is a September 2008 decision. That's Capitol Records versus Thomas, and that's actually hot off the press. I have that here. I'm not going to give you the site because I can't quickly get to it, but I have that here if anybody wants to take a look at it. There is the Universal City Studios production versus Bigwood, which is 441 F. Sup. 2nd 185. That's a Missouri case, 2006. There is Motown Records versus DePietro, which is an Eastern District of Pennsylvania, 2007 case. And the Kahn cases, the one that say making available is not sufficient, is the Elektra Entertainment Group versus Barker case, which is a Southern District of New York case, 2008. And then the last one is Atlantic Recording Corp versus Howe, which is a District of Arizona case, 2008. There, in that case, which is a Ninth Circuit case, that court specifically rejected the, quote, making available theory. Just said no support for it in the law, not going to do it, et cetera. Those are the only cases in America right now. There could be one on Monday, but those are the only cases in America right now that deal with the, quote, making available situation.
Can you do the sites again for the last couple?
Absolutely, I'm sorry, I absolutely will. The Elektra Entertainment case is 551 F. Sup. 2nd 234, Southern District of New York, 2008. Atlantic Recording Corp versus Howe, 554 F. Sup. 2nd 976, and that's District of Arizona, 2008. I think I gave you the Universal Cities site, and I think I gave you the Motown Records site, and the Capitol Records versus Thomas case, which is a District Court of Minnesota. I have here. I don't actually have a site, but I have the decision here if anybody wants to take a look at it when we're done.
So now let's move forward and talk about some of the...
Can I say one
Oh, sure,
thing
of course.
just real quickly, and that is iTunes.
Yeah.
iTunes shows it took Steve Jobs, somebody not in the music industry, to come up with the idea of providing content and having people pay for it. And people pay for the content and don't steal the content, because if you give them a quality product in a timely fashion at a reasonable price and spend your time and energy in developing those formats instead of suing people and hiring private detectives to go find kids on college campuses that are sharing songs with their friends, then you're going to have an industry that flourishes. But the way they're doing it now is the wrong way to go about it. That's all I wanted to say.
Now I want to move into a very hot topic in the entertainment industry, and that has to deal with disputes involving artists and managers. We touched on it a little bit yesterday in a panel, but I want to hear the perspective of that by these panelists. So, Marty, can you tell us what some of the major changes have been recently regarding disputes involving artists and managers?
Yes, talent, dispute between artists, actors, writers, directors, and representatives go back over 50 years. There was a case involving Radin v. Laurie where it used to be known as the Artist Manager Act, and not the talent involving the Labor Code 1700, but predecessor act. And the law used to be two important issues that have changed significantly. The first issue was that if somebody acted as an unlicensed talent agent, and that usually is someone who's in the capacity as a manager, and they violated the law by either offering someone a job or trying to get them work or negotiating a deal. And I used to use the concept, if you got pregnant, you're pregnant. And if in fact you violated the law, the manager had two problems. One, they were not entitled to get paid commissions in the future. Two, if any money was paid to the manager within the last year, or within a year before the filing of the Labor Commission petition, that money had to be returned. And I'll just give you a very short anecdote about a case that I handled a few years ago, which was sad in a way for the manager. I represented the talent, and the person's name was Joe Napoti. He had just come out to California. He was literally broke. He did not have money to pay for his Christmas gifts for his kids. He told his manager, Howard Lapidus, listen, I got Christmas coming up. Do you know anywhere I can get some work or anything? He says, you know what? I'm going to call a friend, a lawyer. They're going to have their Christmas party, and you'll perform, and you deal with them, and they'll pay you some money. So certainly, he got a call. He performed at this Christmas party, made $500. The manager didn't commission it, and he did it as a favor. Well, what happens? 8 years later, the manager had already had an agency involved. A major agency was involved. He had other lawyers involved. Napoti is now on a television series. Well, the manager brings a claim through Patty's office, and not Patty herself, but brought a claim to collect commissions on the television series. Now, so the manager is now saying, I should get paid on this TV series, and it was like about a $300,000 claim to get paid commissions, Howard Lapidus. What happened? We won because that isolated act of procurement, before they even had a written management agreement, was such that we were able to void the contract, which means that manager did not get paid 1 penny in the future. Now, the manager was also smart. If you represent managers, you always want to make certain you don't bring a claim against talent at least until a year has gone by from when you last received commissions. You don't have to worry about paying the money back. Well, now there was a drastic change in the law, complete change in law, and basically reversing the law involving the case of Rosa Blasi, which was handled by Larry Stein's firm, which is on the Blasi case.
It's my firm,
but
too.
not me.
It's my firm, though, too.
But,
and Lawrence.
And
Lawrence. It's actually Lawrence's firm. Larry was partners then with Marshall Grossman, so we didn't consider that his firm.
Don't go there.
I won't go there.
But in any event, this is a unique situation where, quite frankly, people who have handled labor commission cases like I have done, 50 to 100 of them, were shocked at the result. But basically, in the Marathon v. Blasi case, which happened this year, if you want the site, it's 42 Cal 4th 974, 2008 case. And basically, a very similar situation. You have an actress, Rosa Blasi, who's on a television series, had a manager, Rick Siegel, who I've had many cases against, and who's really been championing the law. And even though he won, he's unhappy because it's not the result that he wanted to obtain, because he wanted to obtain a decision that this law, Labor Code 1700, doesn't apply to managers. But in any event, what they held for the first time was an equitable concept that the judges came to the decision is not to have the type of situation what happened with Joe Napoti, which is basically they said, unless you can show that that specific contract that was negotiated, which was the alleged illegal contract. So, for example, I think she was on the show Strong Medicine or something like that. Unless you can show that the manager negotiated that specific deal, if he negotiated other deals, doesn't matter. The manager will be entitled to collect commission. So basically, they obtained the law of severability. So you can sever such now. So the law has changed significantly. And this is a big blow because I would say that 95% of all these cases involve early on in the relationship, a manager was helping out a client, didn't have an agent, try to procure a deal, or while they're representing him, they say, listen, I've got contacts at the studios, I'll set you up a meeting, and just setting up that meeting could void the contract. But the court did hold that even if the manager did not negotiate that specific contract, you could still void the entire relationship and void the contract if you show that this representation was basically that substantial procurement activities you look at the entire relationship and see what did this person do. And if the manager basically goes out, tries to find work, even if they didn't specifically negotiate that isolated case, then in fact, there will, potentially, you will have that contract voided. I had a case afterwards involving Nicolette Sheridan. It was a very close call against her manager. I don't even know if there's any other reported decisions since Marathon where the labor commissioner went back and forth, but then decided on Desperate Housewives, the manager would be entitled to keep the commission. Then a second new case came down this year, and again, a complete concept and a reversal of the law. Going back to 1967 in California, over 40 years ago, there was a case of Buchwald versus Superior Court. Involved the music group Jefferson Airplane. And basically the concept is 9 out of 10 times, manager has a contract with the artist. Usually the manager, if they have a written contract, it says the dispute's subject to arbitration. Or you could file a lawsuit and say, I want to get paid commissions. And the Buchwald case held for the first time, in any controversy where you claim that someone violated the Talent Agencies Act, you first must go to the California Labor Commissioner. California Labor Commissioner, there's a procedure that follows, and then there's a procedure that even if you win, you start all over with a trial de novo. And in fact, for the last 40 years, if not 50 years, that's how all disputes are resolved. Well, in Preston versus Pryor, I had the case. I turned it down in terms of initially, the concept was Judge Alex, I think, has a TV show. A young kid worked at William Morris, Preston, and he was an assistant to the agent, and he basically helped get Alex this job on a TV show, on a television series. Well, the net effect, what happened is his lawyers took the position, well, wait a minute, we don't want to go before the Labor Commission, we have an arbitration provision. But in fact, the law was right on point in Buchwald versus Superior Court. The difference is what Joe Schleimer, or Schleimer and Freundlich did at the time was he decided to go to the federal court under the Federal Arbitration Act, and it went all the way up to the United States Supreme Court. And basically, the United States Supreme Court held, similar to copyright with the concept of preemption, that under the FAA, Federal Arbitration Act, that preempts the state law, so that now, if in fact, which meant that now you had to arbitrate the dispute. So this is a significant impact, which means that now if a manager has an arbitration provision, the Labor Commissioner will not be making the decision as to whether or not someone engaged in an unlicensed talent agent. You're going to still have that type of dispute heard, and they're going to have to follow the Marathon Blasi case. However, you now will have an arbitrator determine that case.
That's the only caveat to that, because I actually read the Preston case pretty carefully. That case assumed, and rightfully so, interstate commerce, because it doesn't discuss the applicability of the Federal Arbitration Act. It assumes it. And the reason I bring that up is if you're sitting here, if you're in Beverly Hills and you got a manager here and you have a artist here, and interstate commerce is not directly implicated. It is certainly implicitly, because if the person is a recording artist, they sell over interstate lines, the whole thing. But it's not clear. If you were drafting an agreement here and you wanted to make sure you didn't get to the California Labor Commissioner, because it's a kiss of death for anybody other than talent, from my own experience, that what you would do is you draft a contract that says the FAA is applicable. Because if the California Arbitration Act is applicable, I'm not sure that you aren't required to first go to the Labor Commissioner, number one. Number two, I think out of an abundance of caution, if you represent the management side or the non-talent side, I think I'd put a provision in that the FAA is applicable no matter what, because there is nothing worse for you that represents the other side of a talent dispute. There's nothing worse than being in front of the California Labor Commissioner, because I don't think they ever rule in favor of anybody other than the talent.
No, that's
not
wait,
true.
can I-
They do favor the talent. There's no. Let me just. Can I give a little context, because we're giving a lot of law, but just so you can understand how this happened. And the court in the Supreme Court decision is very explicit about why they're doing what they're doing and why the appellate court did what they did in terms of severability. And what they basically say is, if you look at the industry, you can't tell the difference between a talent agent and a manager most of the time, the way that they function. Now, the Talent Agencies Act, Jeff Berg and others did a very effective job. It used to be a crime to violate the Talent Agencies Act. They changed that, but the penalties were really harsh. They were draconian. And the reason why is talent agents are regulated. Talent agents have to have their contracts approved by the labor commissioner. Talent agents have to be bonded. Talent agents have to have specific designated agents for projects. They're limited by their deals with the guilds to 10% as commissions. Whereas managers, there is no regulation on managers at all. They can charge whatever they want. Their contracts can say whatever they want. They are totally unregulated. So talent agents would say, since we're so regulated, we're the only ones that should have the right to get someone a job or negotiate a deal. And that's the context in which the court started looking at it. And the reality is a lot of talent would go to their managers and literally say, if you don't get me a job, I'm going to fire you. And those managers acquiescing in the request of those talent would help them. And then as long as the relationship was fine, everything worked out. But as soon as they decided to dump their manager, they would dump the manager would seek the compensation, and by a superior court usually suit. And what the talent would do is run to the Labor Commission, file a petition with the Labor Commission that automatically stayed the court proceeding, the state court proceeding that the manager had brought, and the matter would be decided before the Labor Commissioner. And I don't agree with Patty that they always find in favor, but they are, in fact, an agency placed there to protect the employee. So, and many of the hearing officers aren't even lawyers, incidentally. So, as a result of that, there were a lot of horrendous decisions. What happened? Let me just tell you. What happened was
lawyers, Larry?
some of them aren't even lawyers. The hearing officers.
Maybe one. Oh, that's because you can love those.
Some of them don't even speak English.
So what happened was, interestingly, none of the brilliant lawyers involved, and our firm was involved in it as well, but it wasn't the lawyers that brought up this severability issue. It was the Court of Appeal on its own. The Court of Appeal looked at it and said, this is a tremendously unfair situation. How horrendous to let someone work for 7 or 8 years for someone and then lose the commissions because they helped them in a way that they asked them to help them. We've got to find some solution to this problem. And that's when they came up with the concept of severability. So it was to solve a real problem in the industry.
Here's the bigger problem. The beneficiary of these cases, the structure is upside down. This is really an indirect way of protecting talent agents. And I'm not saying they don't deserve protection. But the problem is you have talent who says, oh, hey, wait a minute, I can take advantage of this and get my money back. Or not have to pay something I agreed to pay somebody. And so the labor commissioner, in terms of following a statute that's really there for talent agents, is basically working a forfeiture and creating a windfall in the benefit of the talent. And maybe the talent agencies should have some right to do something in these situations, but the legislature, which will never deal with this because of the way our California legislature is structured, really needs to scrap this and come up with something that yes, protects talent agencies and protects people against unscrupulous managers. Right. But frankly, the doctrine of unconscionability, it's a really crappy system, and it's being manipulated in a way that's unfair to a lot of people, and I think it stinks. There you go.
It stinks. So let me move on to another area because we're getting closer to
Can I just
time.
ask one question, and that is, did anyone on the panel know whether a lawyer who assists someone in getting a job or negotiates a deal who does not do it in conjunction, because there's a safe harbor if you do it with a talent agent, who does not do it with a talent agent is violating the Talent Agencies Act?
In my judgment, they are, and I actually have had cases that have gone to the Labor Commissioner on that issue. And I do, absolutely, the only way you protect yourself before this decision, which the severability thing is, in my judgment, a great idea. But the only way you protect yourself is if you have the cover of hiring a talent agency, making sure your client has a talent agent as well.
Or you become licensed.
In a lot of situations, there is no talent agent who wants to take that client on, and so there is no, that protection isn't
usually
there.
those cases don't come to us because they don't have enough money.
No, but later on, they become successful people, and anyway. Well,
they see how the law really works.
But there are two cases that deal with the issue whether a lawyer, whether an entertainment lawyer needs to be licensed. There are two cases that I'm aware of. One we handled many years ago involving David Franklin and Richard Pryor. Well, he was an attorney from Atlanta. Part of the problem was he also had embezzled several $1 million, and the court held that he was not protected even though he was a licensed lawyer, and there's a question maybe because he was licensed in Georgia, not in California. And then there was another case about 10 years ago involving, or maybe a little longer, Michael Bergman, who actually is now a litigator, was also acting, where Michael Bergman, who was a California lawyer, also allegedly had violated the Talent Agencies Act by not having a license. He won, but not because he was a lawyer, is that the Labor Commissioner found that he didn't violate the act. However, one thing that we didn't get into this issue of arbitration and Labor Commission proceedings, you have a disadvantage if you go before the arbitration, although you don't really have a right to appeal, although we may discuss that in a few minutes here. But if you have a dispute before a Labor Commissioner, and assuming you're a licensed lawyer, you have a right to appeal a trial de novo. My belief is that you talk about licensing requirements, you really have to be licensed as a lawyer. You have to pass a bar exam. To become a licensed agent, you just need to fill out an application and say, I haven't been convicted of a felony. It's a joke. So I believe that ultimately, that even if a lawyer lost before the Labor Commission, if you went before a court on a trial de novo, there's no doubt in my mind that a lawyer is licensed to practice, and among the things that a lawyer can do is negotiate deals. And therefore, I don't believe you need to have a talent agent work with you if it ever went to
You're licensed, but you don't have all the protections the talent have with a talent agent, because you don't have to have your contract approved by the Labor Commissioner. You don't have to limit the amount of compensation you receive. You don't have to designate people in your office to continue if people leave. I mean, there are all kinds. You don't have to be bonded. There are all kinds of protections.
I happen to think that if you went to the Labor Commissioner today, the Labor Commissioner would find that a lawyer acting as a talent agent is unlicensed and therefore would be subject to the being fined or to have money taken away or whatever. I've been before the Labor Commissioner on this issue, and the reason is, at least ostensibly, whether they're right or not, is for the very reasons that Larry's articulating.
Let me move on to another area, and that is rights of publicity. There are a couple of important things that have happened recently in that area. One in the area of post-mortem publicity rights, which Larry's going to touch on.
No, I wasn't going to do that one.
And there is another area that maybe we can look at, which is with respect to video games and the use of talent in video games. Now, we'll start off with the video games, and basically what's been going on is that there have been video games that incorporate the names, likenesses, and performances of talent, and there have been some major issues that have come up in the right of publicity area in connection with that. And Bobby, can you touch on that?
It's interesting. Video games, obviously we all know about them, and they're one reason why the record and film entertainment industries are suffering, because they are very attractive to kids, and they're willing to spend hours in front of a small screen. The rhythm action genre of video games, particularly games like Guitar Hero and Rock Band, have been a mixed blessing for the industry, and by the industry I'm really talking about artists. On the one hand, both of those games now offer downloading songs, and by downloading I don't mean master recording downloadings, but you can download the song and then play it on the game. Many of these games were developed at a time when no one knew that they'd be successful, so instead of using the master recordings, they went out and got sound-alikes. And we all remember cases like Tom Waits and Bette Midler and the issues that arose there. That has arisen